Is it Gene Falico Living Trust versus Isabel Atkins?
Good morning, Your Honor. Attorney Andrew Babnick, on behalf of the trust. Falcicio, Your Honor.
This case doesn't begin with clarity. It begins with confusion, and in a courtroom, that's already a disadvantage. Right from the opening seconds, you're dealing with a dispute between a legal entity, a trust, and an individual who hasn't even properly established her presence yet. That imbalance matters, because one side is coming in with structure, documentation, and legal representation, while the other side is struggling just to be heard. Now understand this, eviction cases are usually straightforward. Either you have a legal right to be there, or you don't. But when a trust is involved, it becomes even more rigid. A trust is not a person. It's a legal structure that holds property with strict rules. That means emotional arguments, family ties, or verbal promises rarely hold up unless they're backed by documentation. And already, before we even hit the 1-minute mark, there's talk of prior hearings, default judgments, and technical issues. That tells you this case has history. This isn't a one-time appearance. This is a continuation of a dispute that has already tested the court's patience. Watch how the judge handles this. The first priority isn't even the case itself. It's identifying who is speaking, because if the court can't establish that, nothing else matters. Now here's the key question going into this. Is this a genuine misunderstanding, or is this a pattern of delay? Because the answer to that will decide everything.
Isabel Atkins?
Your Honor, we were here last week, so the court is aware, and the court actually granted the default. I logged off, and then I got a notice from the court that Miss Atkins apparently appealed after and said she couldn't unmute. I asked the court at that time to be very candid if it was Isabella Atkins or her mother, Casey. I'm seeing Miss Casey Atkins below, connecting to audio now, but no visual. If it is
Hello?
Casey, if that is
Hello?
Casey Atkins.
Hello?
Hello, what's your name?
Hello? Casey Atkins?
Hello?
Hello? Hello? Hello? Hello?
Hello?
Hello?
What
Hello?
is your-
Hello?
Hello, ma'am. What is your name? Ma'am, what is your name? Casey Atkins.
That is Isabella Atkins' mother, Your Honor, and for the court's record, she was party to another eviction for the trust property in a separate court that we had executed 2 weeks ago. So Miss Atkins' appearance here is not appropriate, and I believe it was her that probably appeared last Friday.
She is also on the phone. We're having issues with the audio. We can call her.
We can call who?
Isabella Atkins, my daughter. She's on the phone also on the 5099, but she's having issues. We're having issues with the video and audio. I don't know.
Okay, but did Isabel Atkins file the documents with the court, or did you?
The stuff that was sent earlier?
Yes, ma'am.
We've now crossed the 2-minute mark, and instead of progress, the situation is getting more tangled. The court is trying to determine something basic: who submitted the documents? And even that question is being answered with hesitation and confusion. This is critical because in legal proceedings, documentation is everything. Who filed it, when it was filed, and whether the opposing side received it, these are foundational elements. If those aren't clear, the court starts questioning the reliability of the entire defense. Now look at the dynamic here. Casey Atkins is speaking, but she's not the defendant. She's answering questions, explaining filings, and essentially acting as the voice of the case. That's a problem, because legally, if you're not a party to the case or an attorney, your role is extremely limited. You can't argue. You can't represent. And you certainly can't control the narrative. At the same time, the plaintiff's attorney is quietly building pressure, pointing out missing documents, lack of service, and inconsistencies. He's not interrupting aggressively. He's just letting the facts stack up. And here's what that does psychologically. It shifts the judge's perception. Instead of seeing a defendant trying to defend her rights, the court starts seeing disorganization and possible manipulation. Now think about this. If you were the judge and you're seeing unclear filings, third-party interference, and constant technical issues, how much confidence would you have in this defense?
Yes, it was with me. It was me allocating it. And she,
Okay,
I
but-
mean, like I said, she's on the phone. She's trying to call. She's flipping out.
Your
I'm
Honor,
sorry.
I didn't know that there were documents submitted. We didn't receive any document. I'm not sure what the court would be looking at.
I somehow figured that.
Coming in. I have more.
What do you mean there are more coming in?
I have 2 additional emails that were sent at 9:25 this morning from Ms. Casey Atkins.
Oh, I don't
Each
know.
with 10 attachments in them. More pictures.
More pictures?
I don't know.
Well, they were,
Ma'am, please. Okay, let me try this first of all, counsel. There's someone who is dialed in whose last 3 digits are 699.
no, the call that I'm on with my daughter ends in 99, but it's 5099.
Okay. Could
Your Honor.
the individual who has logged in with the last 3 digits 099, you need to hit *6 on your phone and identify who you are.
The issue may be, Your Honor, too, if she is simultaneously on the phone with her mother, you can't 3-way call into a Zoom, so you would have to hang up with Casey, her mother, to then appear through the audio.
Individual who's logged on with the last 3 digits 099, you'll have to unmute. If it is a 3-way call, counsel's right, then you're gonna have to hang up from one of them, but preferably the one hooked to Casey, if you are Isabella.
Now we're past 4 minutes, and the court is still dealing with access issues. That alone is damaging, because timing matters. In a structured hearing, every delay disrupts flow, wastes court time, and signals lack of preparedness. The attorney makes a sharp observation here. You cannot 3-way call into a Zoom hearing properly. That's not just a technical note, that's a procedural breakdown. And here's why it matters. If Isabella is connected through her mother, then every word she says could be influenced, coached, or even filtered. Courts require direct communication to maintain integrity. Notice how the judge starts giving instructions more firmly now. Press *6, identify yourself, disconnect properly. The tone shifts from patient to controlled. This is where the defense begins losing ground, not because of law, but because of execution. And here's a deeper layer. Every time the court has to repeat instructions, it creates doubt. Doubt about competence, doubt about independence, doubt about credibility. At this point, the judge isn't just evaluating the case anymore. He's evaluating whether this process is even being taken seriously.
Casey Atkins, unmute, please.
Trying. We're having issues
Okay. Where is Isabella?
with her boyfriend right now. Then she at his place, and that's why we're doing the 3-way. And she sent me a text that she's doing the *6, but it's not doing anything, and she's having a hard time hearing.
Ma'am, Isabella needs to
Yes.
call in on her own. She's the only one that's
Okay.
a party to this case.
Okay. Okay, can I have a few minutes to get through to her?
I'm sorry?
Can I have a few minutes to get through to her? Because I'm gonna have to hang up. She's having issues, and I'm gonna have to get her to call from she can't hear anything. She's not hearing anything we're saying. She's sending me texts. So can I have a few minutes to call her and tell her to call her boyfriend or something?
Well, is there area code is her area code 734?
Yes, sir.
I'll give a couple minutes to call in. Counsel, you were going to say something, sir. I'm sorry.
We're now around 6 minutes in, and the judge does something important. He grants time. That's not weakness, that's controlled flexibility. Courts understand technical issues happen, but they also expect that when time is given, it's used efficiently. Now observe the attorney's move here. He suggests moving the case to the end of the docket instead of delaying it entirely. That's strategic. It shows cooperation while still protecting momentum. Because what he's really saying is, give her time, but don't let this derail the process. And that's a powerful position. It frames him as reasonable while subtly reinforcing that delays have already gone too far. Meanwhile, Isabella still hasn't clearly appeared. Her mother is relaying messages, describing panic, explaining confusion, but none of that replaces actual legal participation. This creates a critical perception issue. Is the defendant in control of her own case? Because if the answer is no, the court is far less likely to trust anything that follows.
No, Your Honor, I was going to say if the court needs to move on to other files and move us to the end of the hearing to give her time, I just don't want to let this delay another day, and I know it's going to keep moving. I don't have another hearing this morning, so I can hold on if need be.
Okay. All right. She needs to call in, ma'am.
Okay.
Quarter past that case. The individual who signed in, last three digits of the phone number 711. Could you please hit *6 and unmute and identify yourself? Oh, really?
Hello, this is Bella Adkins, Casey Adkins' daughter.
Yes. All right. Okay. This was a termination case, correct?
Correct, Your Honor.
And ma'am, what's your claim to your ability to reside in the premises? Miss Atkins?
These are the new documents that they filed, but they're back and forth.
Got it.
Your Honor, if those were emailed to the court, obviously the court's aware, but just for the sake of the record, nothing was emailed to me.
Yeah, I got it, counsel.
Thank you.
Yeah, you can forward them to him. I mean, we're going to try to forward those to you, counsel, so you.
Thank you, Your Honor.
I have a property transfer affidavit from January 25th of 2023. The seller being Gene, is it Facio?
Falciccio, Your Honor.
Falciccio. And that the buyer is Casey Atkins.
Your Honor, Miss Atkins filed 2 property transfer affidavits on the date of her mother's death. The property is not, Miss Falciccio died in January. She passed. Both of the properties that were, one, an eviction's already occurred. This is the last one, are titled in the name of the trust. So that affidavit is a fraudulent transfer affidavit. Title remains, and I could show the court the deed and the recording information. The title remains vested in the trust.
Got it. Okay, Isabel Atkins, what is your claim to the premises that's at issue here?
I would like to request a jury trial. I lived with my grandma for a year.
We've crossed 9 minutes, and this is the defining answer from the defendant. I lived with my grandma. That's not a legal defense. That's a personal statement. And this is where many cases collapse, because people confuse permission with ownership or presence with rights. Living somewhere, even for an extended period, does not automatically grant legal residency, especially when the property is owned by a trust. The judge immediately identifies the issue. There's no legal foundation here, no lease, no contract, no enforceable agreement. Now pause and analyze this. If verbal permission from a relative were enough, property law would be chaos. Anyone could claim residency based on past conversations. That's why courts require documentation. And this is the moment where the defense shifts from weak to nearly non-existent.
Ma'am, you've got to file paperwork and you've got to pay for the jury. Are you going to do that today? And then you're going to have to file an answer to the claim.
Yes.
So the court is aware, just from a timing standpoint, I did just receive the email from the court showing photos, which appear to be the photos of the property being removed from the first eviction unrelated to this property. There was a proper notice sent for possession. A notice to quit was sent all the way back on May 18th, giving them until June 30th to vacate. We delayed the filing of the eviction to give her even further time. There's no defense that's been raised, and even her claims on the record here that she would simply like to stay do not give her grounds. There's no lease. She needs to vacate the property, and at this point, we'd ask for no further. This is the third time they tried to delay this. We'd ask for no further delay.
At around 10 minutes, the attorney delivers a structured, precise argument. He lays out the timeline, notice given, extended deadlines, no response, no defense. This is exactly how you win an eviction case, because courts don't just look at the present, they look at the history of compliance. And here, the history shows delay after delay. Also notice the restraint. He's not asking for money, just possession. That positions his request as fair, reasonable, and focused. Now think about the contrast. One side is presenting a timeline backed by action. The other side is presenting requests without substance. That imbalance is almost impossible to overcome.
And for the judgment to be entered, not seeking any money judgment here, obviously, Your Honor, but just asking that the court enter the judgment in an order of eviction in 10 days.
Miss Isabel Atkins?
Yes.
What is your basis for claiming that you can reside in the premises?
My grandma said that I could.
Okay, ma'am, that's not going to be enough. I don't really have an issue that I could try or a jury could try on this case.
For the sake of the record, Your Honor, I would like to ask, is Miss Atkins alone, or is Miss Casey Atkins with her? Because Miss Casey Atkins, who's not a party to this case or an attorney, continues to appear on the Zoom.
No, I'm on the Zoom. I'm not with Bella.
Okay, Isabella?
Sir, the request is that we would like to get it moved to probate, as the trustee is not listed as the plaintiff.
Ma'am, you are not a party to this case.
Your Honor, now that she's muted, just so the court is aware, Miss Casey Atkins tried to file a probate action in front of Judge O'Brien, which was just recently dismissed. This is just a sort of belaboring continuous fraud to keep the properties in play, and we would just ask for the judgment at this point. I really don't want to belabor the issue further.
We're now past 12 minutes, and the tone escalates. The attorney introduces the idea of continuous fraud. That's not a casual statement. That's a serious allegation. He's essentially telling the court, this isn't confusion, this is strategy. And then the judge reinforces control, shutting down Casey again, reminding her she is not a party. This moment is critical because it establishes authority. The courtroom is not a place for multiple voices competing. It is a structured environment where only recognized participants matter. And here's the turning point. The judge stops entertaining possibilities and starts forming conclusions.
Andrew, that's not true. Y'all haven't filed the will.
Yeah, Miss Atkins, Casey Atkins, I've now for the third time told you you are not a party to this case. Isabella Atkins, tell me every reason outside, well, you said your grandmother said you could reside there. Any other reason you think that you're able to reside in these premises, ma'am? Isabella Atkins, are you there?
I will file paperwork.
You what?
I will file paperwork, but I would like the right to have a jury trial.
Well, ma'am, I need to know that there's a defense to the claim.
Your Honor, this may be strangely odd, but I'm concerned that that may even be Isabella Atkins on the phone. If the court recalls when this started, there was a different number.
Now we're past the 14-minute mark, and something significant happens. The attorney questions whether the person speaking is even Isabella. This is a critical credibility collapse, because in court, identity is not optional. If the judge cannot confidently verify who is speaking, then everything that follows becomes unreliable. Notice how the attorney frames it carefully. He doesn't accuse directly, but he raises concern about the voice, the number, and the inconsistency with earlier issues. That's enough to plant doubt. And once doubt is introduced, the burden shifts. Now the defense has to prove legitimacy, not just of their claim, but of their presence. The judge acknowledges it immediately. That's key. It means the concern isn't dismissed. It's absorbed into the court's evaluation. Now step back and analyze this moment. We started with technical confusion, then procedural issues, now identity concerns. This is a downward spiral, because at this stage, the judge is no longer asking, do you have a defense? He's asking, can I even trust what I'm hearing? And when a case reaches that point, the outcome is usually already forming.
That was saying it was having issues calling in. Now there's a new number, video, but the age of the voice, I'm just concerned. I
hear you. I got you. Miss Atkins, Isabella Atkins?
She just
logged off. Okay, here's what I'm going to do.
Sir, she's calling me right now. Bella, are you on the phone? You're on the phone with the speaker with the Zoom, Bella. It's okay. Sir? Hello?
Isabella Atkins.
Bella, answer.
I don't know how to answer this question.
Okay, I have a very clear picture now of what's going on here. So here's what I'm going to do. Because I don't think this is, I think Isabella's there, but Isabella, I don't think wants to pursue this in this fashion.
At around 15 minutes, the judge makes the decisive shift, from questioning to concluding. I have a very clear picture now. That sentence carries weight. It means the court has gathered enough information, observed enough behavior, and evaluated enough inconsistencies to make a ruling. And look at what the judge identifies. Isabella is present, but not in control. The situation is being influenced by someone who is not a legal party. That distinction matters because it undermines the legitimacy of the entire defense. The judge then states there is no triable issue. That's a legal threshold. It means there is nothing substantial for a trial or jury to decide. No facts in dispute, no valid defense, no legal claim. Once that threshold is crossed, the case is effectively over. Now consider this. All the requests for time, all the confusion, all the attempted filings, they don't matter anymore, because none of them established a legal right. This is the moment the case ends, not emotionally, but legally.
So she's going to have to get an attorney so that the record's clear. I think much of this is being instituted by Casey Atkins, who's not a party to this case. So I'm going to find that there's no tribal issue in this case after hearing. I'm going to grant a judgment for possession to the plaintiff with a writ 10 days.
10 days. Thank you, Your Honor. Your Honor, can the proposed orders be submitted to the court via email, or do they need to still be paper?
Yes, that you can submit them to the clerk's office via email.
Thank you, Your Honor.
Thank you.
The court's time. Have a good
Is that
weekend.
it for us? You do the same, sir. Huh? That's it for that block. We will begin again at 10.
Court Feaster, Assistant Public Defender, on behalf of Mr. Javante Jackson, come to the podium. Mr. Jackson, when you arrive, please state your name for the record.
Javante Jackson.
Thank you.
Thank you, Judge. I did speak to Ms. Zinda on this matter. I know she has something she's gonna be requesting. I also met with Mr. Jackson in custody on Tuesday. We are gonna be requesting an adjournment to try to get some new information, discovery that Ms. Zinda is going to talk to you about here momentarily, Judge.
All right, yes.
If I could address bond, it came to my attention that Mr. Jackson has called the victim. There were 3 complete calls that were just about a minute long. In those calls, the victim calls him by his nickname that she referred to him in speaking with her brother, who's also in custody previously, and is immediately upset that he's calling her, tells him to stop calling her. And then after those calls are complete, he has about 180 attempts to call her that she does not pick up.
At around 17 minutes, the situation escalates dramatically. 1 or 2 calls might raise concern, but 180 attempts? That's not a mistake. That's a pattern. And in legal terms, patterns are powerful evidence. The prosecution lays it out clearly. Repeated contact, ignored requests to stop, violation of probation conditions. This transforms the case from procedural to behavioral. Now the judge isn't just evaluating facts, he's evaluating risk. Risk to the victim, risk of continued violations, risk of non-compliance, and when risk increases, judicial tolerance decreases. Here's the key question. If someone ignores clear legal boundaries repeatedly, what reason does the court have to trust future compliance?
So at this point, I'm going to ask that his phone privileges be revoked, and we will be blocking her number from the jail, given that he's tried to call her 180 times. And all of that is in violation of the probation that he's on, the 14B, with the domestic violence second offense case that he had with her. So I have concerns that he's still violating both the PPO and his probation concerns at this time.
I was made aware of that this morning, Judge. I haven't spoken to my client about it. Obviously, I'll reserve comment until I receive phone calls from Ms. Zinda, but I understand what the court's likely to do.
And he's on probation in case involving her, which would contact would be prohibited. Contact is prohibited in this case.
And there's a PPO.
And in listening to at least the portion of those calls, there's an indication that the victim has said that to stop contact.
In pretty much all of those calls.
That from this court standpoint seems rather egregious in terms of behavior. Certainly he would be entitled to a hearing on it. But at this time, there's going to be I don't think he can behave himself if he ever got out. So not only are his phone privileges hereby ordered revoked, the defendant's bond is also revoked at this time.
The consequence is immediate: bond revoked. This is one of the most serious decisions a judge can make in a pre-trial setting. Because bond represents trust, it allows a defendant to remain free under the assumption that they will follow conditions. When those conditions are violated, especially repeatedly, that trust is gone. Notice how the judge phrases it. I don't think he can behave himself. That's not just frustration. That's a legal conclusion about behavior and risk. And once that conclusion is reached, the outcome is inevitable. Now consider this. The defense hadn't even fully responded yet, but the evidence presented was enough. That's how powerful documented violations can be.
Thank you, Judge. I'll get a copy of those calls from Ms. Zinda and I'll take them over for my client to listen to.
Court calls the case People versus Daniel Cummings.
Assistant Public Defender Sandra White on behalf of Daniel Cummings. Can you state your name, please?
Daniel Cummings.
Your Honor, we're going to ask for an adjournment so that I can have more time to speak to Cummings and the prosecutor. Mr. Cummings is asking for an adjournment about a month out. He has different procedures coming up and he wants to get all of his dates together.
You've seen his test result? Apparently not.
Yes, we discussed.
From the 24th?
Just a second, Your Honor.
Counsel approach.
Yes, we're trying to review this treatment.
You might want to get that button.
Your Honor, can we get an adjournment for about a week so I can?
Yes, and just so that we know that on the 24th of November, defendant tested, which is actually only tested, he's taken and he tested positive for fentanyl.
We're now around 20 minutes, and another case introduces a different issue: substance use while under court supervision. The defendant tested positive for fentanyl. In isolation, that's serious. But in the context of bond or probation, it becomes a direct violation, because conditions of release often include sobriety requirements. Violating those conditions signals non-compliance. The judge responds decisively: adjournment granted but bond revoked. This is a pattern you're seeing repeatedly. The court allows process, but enforces consequences, and that balance is essential. It ensures fairness while maintaining control.
In this case, so
It's,
And Mr. Yes, Your Honor.
so I'm going to adjourn this out to December 11th, 2025, 9 a.m. This time, defendant's bond is revoked, defendant's remanded.
Yeah.
Court calls case People versus Moses, Hennigan Page.
Assistant Public Defender Jay Bellinger on behalf of Mr. Finnegan Page, Your Honor. Mr. Finnegan Page, can you please state your name for the record?
Moses Finnegan Page.
And Your Honor, we are aware of the violation. I have been able to go over that with my client. My client's willing to speak to that with regard of his willingness to check himself into an inpatient facility or do an outpatient.
Does he admit to the violation?
Yes, sir. If I test today, I'll be clean.
Go ahead, Mr. Bellinger.
Otherwise, Your Honor, we would be asking to, I would be asking to adjourn this matter just a couple weeks so that I can look into a few different things that Mr. Finnegan Page and I discussed.
Probable cause conference will be adjourned to December 23rd, 2025, 9 a.m. October 28th, November 13th, November 24th, you are positive for cocaine.
Yes, sir.
All while you're on bond.
Yes, sir.
Not appropriate. Can't happen.
At 21 minutes, another defendant admits to multiple positive tests for cocaine. Now here's what stands out: admission. That can sometimes help a defendant because it shows honesty, but it doesn't erase the violation. The judge's response is direct: not appropriate, can't happen. No ambiguity, no negotiation. And again, bond revoked. This reinforces a clear pattern across cases. When conditions are violated repeatedly, the court escalates consequences because the system is built on compliance. Without it, the entire structure fails.
So at this time, you're going to have to figure out some regimen for some treatment because apparently he's not doing it on his own, counsel. So at this point in time, his bond is revoked, defendant remanded.
Thank you. I will present an order to the court at the appropriate time for hopefully some inpatient treatment.
Court calls case People versus Sandra Law.
Ashley Phelps for the people.
Stephanie Tanner on behalf of Ms. Law.
Ms. Law, could you please state your name for the record?
Sandra Law.
What are we doing?
Thank you, Your Honor. So a part of what we had been discussing with the prosecutor's office required my client to be in some sort of treatment. However, and the court did the order, but not been released to treatment yet, as the court can see.
Is that because they can't find something?
They're waiting on beds. Yes, Your Honor. They're waiting on beds. Your Honor, my client is asking if the court would consider allowing her to do outpatient treatment instead. She could go on a tether. She believes the court may remember this. She's being evicted. It was before the court, and she has until the 12th of December to get her property out of the home, or they're just going to put it on the street.
That was a case before me.
Yes, it was a case before you, Your Honor.
Just let me tell you the name.
Give me a second.
Who was your landlord?
It was Thomas Berry and my daughter Serenity Sturman.
What did you say? Go ahead.
It's Thomas Berry, which is my daughter's ex-boyfriend, and her name is Serenity Sturman, and she just turned 21. And she's going through a lot of problems with this man.
All right, I got you. I just need to know who the landlord was. Got it?
I do. It's dismissed on October 24th.
That case was dismissed.
When?
October 24th.
October, it couldn't have been, because we have a thing.
Okay.
There's another one, you just
Do
missed
we
it,
have
and you had to
another?
refile it.
Hold on.
There is no other newly entered case in Vegas.
We don't have another case.
Because they said that you said, because I watched the thing, Your Honor, and you said that he had to refile it, because he didn't file it right. He put her name, so he had to refile it under Serenity Sturman and all other occupants. And it's for.
Okay, but I don't, we don't have a
Court has
case.
indicated that as of right now, there's no eviction, is what he's trying to tell you.
It's like we have to move out, or we have to get our stuff taken out by, it's a, no, I don't know what you call it. The paper said,
There's a notice to quit.
yes, I mean, that's what it is. We have to help by the
and
12th.
it tells you that you have a certain period in time in which to move out.
Now we move into another situation involving housing, but this time it's tied to treatment and personal hardship. The defendant is dealing with eviction, rehabilitation, and family responsibilities all at once. This introduces a different dynamic: mitigation. The defense is trying to show context, waiting for treatment, lack of available beds, external pressures, and the judge responds with a mix of structure and understanding, explaining how eviction notices work, clarifying timelines, and maintaining legal boundaries. This is a different tone from earlier cases, because here the issue isn't manipulation, it's circumstance.
Right, okay, that's what.
If you don't, then what happens is they file a court case and it comes before me.
Judge is saying you have more time.
Right, but will I be out of rehab before that?
I have no idea when you're gonna finish rehab.
Okay, I do have a job. I do have my daughter to take care of. I do have a job. I am enrolled in school through Yale online. Your Honor, I did that to the family. I made a mistake.
No, we're not gonna admit, we're not gonna talk about any of that. Your Honor, my client is just waiting to be released into inpatient treatment. As you can see, she's anxious to get out and to do so.
Can I please be released? I've never missed court dates. I've been on probation with Judge Washington. I've
Your
passed
Honor,
all my jobs.
did I give you a green sheet, Mr. Allen?
Yeah, I have a green sheet. How
So,
much
Your Honor, we're asking for just a 2-week adjournment. We just need to get her in treatment so that we can work on an offer.
will be adjourned December 18th, 2025, 9 a.m. Bond continued. Thank you.
Be released to outpatient treatment.
He said no.
She did not know that we know there's no case pending. I'm making a note. If he messes it up, I'm taking it. Court calls the case, People versus Suzette Hampton.
Assistant Public Defender, Secretary, I can rule, Your Honor, on behalf of Ms. Suzette Hampton, we are both approaching. Hampton, state your name for the record, please.
Suzette Hampton. Yes, I was on time. I got you.
Your name, ma'am?
Suzette Hampton.
All right.
Judge, in this matter, we are asking.
Seeing her progress report.
I did, Your Honor. I was speaking with Ann about that. I did get a copy of it, and we've spoken about it. If I'm not mistaken, this report is in regards to a missed test on the 24th. Is that right?
Well, there are two issues involved in that because I don't recall. Okay. And that was the test. Well, no, that was back then. the test date was on the November 24th, 25th. That was a missed test. She said she was traveling. Where was she?
I was on my way to Virginia.
Pardon?
I was on my way to Virginia for the holiday. I had stated that before, but
Pardon?
Your Honor, Ms. Hampton indicates that she was on her way to Virginia. Now, at our last hearing, I thought that we had requested to the court the permission to travel. I know if the court can recall
In
that.
September, I have the order. On September 25th, 2025, she requested permission to travel, which I granted, allowing her permission to travel to Virginia from the dates of September 26th through October 1st, 2025. After that, there was no permission granted for her to travel.
And Your Honor, I think that I do know Ms. Hampton and I had discussed it. For some reason, I was under the impression that we requested that. Ms. Hampton.
That you had requested what?
The permission to travel during that holiday period. Can we approach, Your Honor?
No. Just gonna let you flail out there.
Don't do that.
Come on.
Thank you, Your Honor.
Hey, we're back on the record. What is clear to me is that, ma'am, I'm just gonna explain this to you, because I do need 2 travel requests before you've always gone, come back without incident. Apparently, you thought that you had permission of the court to travel this time.
Yeah.
Did not. There's no order reflecting that. So it's okay. I'm not going to do anything about that. And the travel that you made was over the holiday, which kind of makes sense to me. So I don't know if it got overlooked. Don't know. There were a lot of travel requests coming in around Thanksgiving, so I get it. But I'm just going to tell you, you need to make sure that there is something in order in place, or that the court has given you permission before you leave the state of Michigan. You understand that?
Yes.
All right.
Around 30 minutes, the judge addresses a travel violation, but handles it differently. Instead of punishment, he offers explanation. Why? Because the violation appears unintentional. The defendant believed permission existed, and in law, intent matters. So instead of revoking bond, the judge corrects the behavior, clarifies the rules, sets expectations, and allows continuation. This shows the contrast in judicial approach. Deliberate violations leads to strict consequences. Misunderstandings leads to corrective guidance.
So you want this adjourned out?
I do, Judge. And we would be asking for a January date. We'd actually be making another travel request. On the record.
January 8th.
That is fine, Judge.
That'll work?
Yes.
January 8th, 2026, 9 a.m. Right? At the bench, you said you wanted to go to New York.
I'm sorry?
To New York?
Yes, sir.
Why? Nobody really goes to New York.
Well, my son, since the last time I didn't get to travel, I didn't. And that he wants to take me to New York and also to see the ball drop. So
to see what?
The ball drop for New Year's. So he wants to bless me this year.
Man. See, I was going to deny it. Her son get to do anything. He's going to take it. Cool.
Thank you.
Actually, have you ever been in Times Square when that's happening?
No, sir.
Oh, you'll want to do it once.
That's it.
And never again. I mean, it's whatever it is, but it's a lot for the day to get to that point. I'll just put it that way.
Okay.
I mean, but that's what you're into. That's what you're into.
That's what he wants to do for me.
No, but if a son's gonna take his bomb to do, far be it for me to stand in the way.
Okay,
All
thank
right.
you very much, Your Honor.
So, and I understand, so what I will do is I will permit that travel. Council will be arranging so that somewhere there she can test, whether it be EGG testing, so we have some consistent test in the interim.
Absolutely, Your Honor.
All right, so if you prepare an order to that effect, then I will sign.
I will.
All right,
All right.
bond will continue.
Thank you, Judge.
States People versus Jimmy Lee Perry.
On behalf of people.
Assistant Public Defender Sandra White on behalf of Jimmy Perry. Can you state your name for the record, please?
Jimmy Perry.
Oh, sorry, Your Honor, we're asking for an adjournment in this matter. And it looks like there may be a conflict, so our office is looking more into that. And I did discuss the bond violation.
At least for the purposes of the violation, do you know about the violation?
I do know about the violation, Your Honor.
Why don't we address that, and that way I can figure out how long I'll put it out.
Okay. So it looks like, for what I see, that the intake was on the 21st, which is the first day of the violation. And then the next one was for the 24th. So from what best that we could tell is that the chemicals are still getting out of his system.
Really?
Yes.
21st to the 24th. He's testing positive, but it's getting out of his system.
Well,
So if I send him for a test right now, what would happen?
oh, he's saying yes, Your Honor.
Yes. He said what?
He would be negative, yes.
Yeah, I got it. Why is he testing positive anyway?
I haven't, Your Honor, I got too much going on. There's no way I'm gonna jeopardize what I got going on, but JLP World Enterprise. What we have to offer is a holding company for Green Flow Equity Group. Restaurant owners need this, it's revolutionary, and we crossing the whole United States with this.
So I think he's saying, Your
What
Honor,
is he talking about?
I think he's saying that he has to, he will test negative, Your Honor.
What?
He will test negative.
But why was he testing positive?
Well, Your Honor, we don't want to discuss that without having a hearing.
You want a hearing?
No. Hold on, Your Honor.
He's either going to admit to the violation or we're going to have a hearing.
I've been doing it.
What's that?
Of course.
He said before he was jailed, he did take cocaine and fentanyl, Your Honor.
What extra thing?
Well, it sounds like it
Do
was.
you really want me to get the numbers to see if they've gone down? Because if I get the numbers and they haven't gone down, we're going to have a real problem.
It's my laptop. I'm just there. No. Nothing. But what if they want? Yeah, before
you went to jail.
Absolutely.
I guess we're gonna have to get those numbers, yeah.
Well, I don't know if I can get it today. All right. Well, here's what I'll do.
I would just say, he was arrested on the 19th. He would have a positive 5 days after he was arrested, which I understand there's a couple days, but 5 days, in my experience, way outside.
Way outside, exactly, for these two.
I understand what they're saying. They're saying that it should still be in your system level.
Haven't done anything.
Well, I'll tell you what. Does he want a hearing?
What's up?
I haven't done anything.
Okay, sounds like he wants to hear it, Your Honor.
You want to hear it? All right. I'll set a bond violation hearing. As well as I'll set his probable cause conference. I'll set that for December 11th. Give it a week out. Hopefully we get everybody here. December 11th, 2025 at 3 p.m. In the interim, pending that hearing, defendant's bond is hereby ordered revoked. Defendant's remain.
Thank you, Your Honor.
As we reach the final segment, the pattern becomes undeniable. Another violation, another hearing set, another bond revoked pending resolution. And this is the broader takeaway from everything we've seen. Courts are consistent. They allow time. They allow explanation. They allow process. But when behavior shows disregard, whether through repeated contact, substance violations, or procedural manipulation, the response is firm. Now step back and look at the full picture. The first case failed due to lack of legal standing and credibility. The following cases show a pattern of defendants testing the limits of compliance. And each time, the court responds the same way. Structure, evaluation, decision. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.